everyone, we are back and ready to go for our last session.
Before lunch.
Yeah, before
Not
lunch.
the last
Not the
one.
last one. I was gonna say of the morning, but let's make sure we share this first. Okay. Before lunch, we have our very own Joe Hayes talking about COVID and general safety and employment law updates. Joe has been with the Alliance Group since October of 2015. He works exclusively inside our human resources and safety teams. Prior to joining TAG, he spent 11 years as a practice manager for Bellevue Animal Hospital. Joe happens to be a huge bandwagon Lakers fan ever since LeBron joined the team and enjoys participating in our monthly taco truck lunches. So Joe Hayes, if you have anything else you'd like to say, I'm happy to introduce you, but I will pull up your presentation here, and then I will give you the reins, my friend. Let's get this back. I always forget to do this. All right, Joe, you are good to go.
All right, so thanks for the introduction, Taylor,
No problem.
except for the LeBron part. I am a Lakers fan, just not a LeBron fan. So anyway, let's kind of talk about some COVID, some general safety and employment law updates. So we'll kind of hit on that a little bit. Hope everyone's enjoying the summit so far, and thank you for attending my session. The majority of my session is actually going to revolve around everyone's favorite subject, COVID. So please don't leave now. There's a lot of safety considerations and stuff that we're going to be discussing. So we'll be talking a lot about that, and then we'll kind of hit at the end a little bit some HR and other safety topics kind of at the end there. So, all right. So starting here with a little bit of coronavirus stuff, we definitely, a lot of people I know are ready to move on from that subject, but we definitely don't want to let our foot off the gas too soon when it comes to kind of tying in safety here, just safety in the workplace. So also there's a lot of people that are very fearful of this pandemic still. So we have to kind of keep in mind their considerations and their concerns. So relaxing on these measures too soon can also invite litigations and fines from OSHA. Actually, from July of 2020 through April 1st of 2021, OSHA has issued 650 citations related to COVID with penalties exceeding $4 million. So it's definitely not something to take lightly. Various employment law firms estimate that over 3,000 lawsuits have been filed related to employee safety in regard to COVID. And that was between March 2020 and October 1 of 2021. So not even a whole year time frame there. Well, I guess it is a little over a year. But basically those same law firms are saying they do not expect that to decrease anytime soon. So people are definitely still concerned with their safety. So with all that being said, there were some statistics and stuff there. There's some things that we can definitely do to decrease our chance of being part of those statistics. One thing we'll kind of talk about is the emergency temporary standard. And if any of you have been following the news, pretty much have to follow it every day to know this, but right now that emergency temporary standard that was supposed to be in effect has now been put on hold. Both kind of by a lawsuit, and actually OSHA put it on hold themselves until further notice. The most recent update indicates that they're currently taking public comment, and that has actually been extended to January 19 of 2022. So if this is a subject that you'd like to weigh your thoughts on with OSHA, and I'm sure we all would, then it's something that you definitely want to do before that date. So
yeah, and I think, sorry to chime in, but on the public comment, I think another thing I had been reading when I was doing research on that previously was that they were also thinking originally when they put out this employees with 100 or more need to have your workers vaccinated, they were thinking about extending this to smaller businesses. So don't think that you're off the cuff or off the line because you're a smaller business and you don't have 100 or more employees. You should go still put a public comment out there to make sure that your voice is heard, so that if you don't want this to come down to smaller businesses, then you need to let them know why and what impact that would have on your business.
Yes, absolutely. Thank you, Trey. So just everyone kind of just wants to somewhat familiarize themselves with this standard, because obviously there's no guarantee what these lawsuits will what will happen with these lawsuits and if OSHA just pursues with it. So definitely want to familiarize, and I'm going to cover a little bit about it because I do think it's important for at least people to understand a little bit about what to possibly expect on that. So we'll start here with kind of covered employers, at least initially what the plan is. All employers with a total of 100 or more employees while this ETS is in effect will be expected to comply with it. So that even means that if you are at 98 when they initiate this and you happen to go into 100 during that ETS process, that makes you now qualified to fall under the requirements of that. So it doesn't matter what your employment number is on that day, it can change. However, the opposite actually does matter. They have said that if you are 100 on that day, you don't get to go in and out of it just because you fluctuate from 98 to 100. If you're 100 on that date, you have to stay in it during that period. So that was something very interesting too. So it does include full-time, part-time, and temporary employees when you're looking at that number, but it doesn't include if you have independent contractors. And then like franchisees, if they're independently owned and operated, then you actually only count your total. So if you own like 4 of them or whatever, that could be combined, then that you won't count your whole entire McDonald's or whatever. If you own 5 McDonald's, then you're worried about your group of 5 people or 5 places. So so again, sort of further on that, it is also firm or corporate wide. So it's not just based on individual locations. So if you're one of those companies that has 5 different locations, all 5 locations matter in that count. So if you have 25 people at 5 locations, you're over 100. So you have to count all of those employees and you're required to comply with that. So, so that's important with that. What's not covered is employees that are not reporting to the workplace where coworkers and customers are present. So that's not counted. If employees are working from home, then you don't have to follow the ETS. Employees working exclusively outdoors don't apply. However, if the company has both an office base and exclusive outdoor people, like maybe a fence building company or some construction where they have maybe 5 or 6 people in the office, but they have 100 and some people out doing the labor. The office people are expected to comply with the ETS in that situation, but everyone outside are not expected to comply with that. Kind of an interesting way of putting that, but as far as the counting of the numbers, your business has to comply with that, and everybody in the office will have to follow those rules. Workplaces under the federal contractor and subcontractor guidelines also are not covered in this ETS. They kind of have their own separate thing. And also employees that provide healthcare services and support are subject to that COVID-19 healthcare ETS. However, again, I'd like to reiterate that both of those have now had lawsuits filed. So I think tentatively both of them are technically on hold at this point. So kind of up to you if you're going to kind of stick with those guidelines for now, depending on what happens with those lawsuits. But at least at this point, they appear to be on hold. So what are some of the requirements that are in that ETS? A vaccine mandate policy will be required. Weekly testing options for those who are not vaccinated. Employee notification. So like if there's positive cases reported and those kind of things, then you're required to notify employees of that. Face coverings. So if they're not vaccinated, then they do have to wear a mask. Information to employees. So there's some things that you have to share with employees, at the beginning of this. So there's information about the vaccine. And you do have to use like CDC stuff, not your own personal opinions on the vaccine. You do have to give them the OSHA whistleblower information, which is about retaliation and discrimination. We're actually going to talk about that here in a little bit. And then you do have to report to OSHA, depending on the source of the COVID positive case and hospitalizations and that. And that's something I'm also going to kind of talk about in a little bit more detail here in a moment. So, but those are the basic requirements, at least at this point, that are on that ETS. So until that ETS takes place, there's at least 3 things pretty much that still apply to what's going on today that are not part of any ETS or anything like that. And those are some basic standards that OSHA has out there all the time. So it really matters completely as a whole. So the first one is OSHA's PPE or personal protective equipment standards. And that requires a PPE hazard assessment be conducted to assess workplace hazards, make sure that there's proper PPE if needed, like respiratory protection or whatever may be used as necessary. This actually is a standard that applies all the time, but definitely applies to COVID situations at this point in time. And then there's the general duty clause, which is just flat out OSHA's, like it says, their general duty clause. It requires employers to furnish a workplace where workers have employment and a place of employment, I'm going to read it verbatim, which are free from recognized hazards that are causing or likely to cause death or serious physical harm. So that is something that they feel qualifies as a COVID concern. So you definitely will want to comply with that as well. So it is important that we kind of evaluate the hazards and stuff, potential hazards at our workplace. And then there's the OSHA whistleblower program that we kind of mentioned a little bit earlier. And this actually protects, it has provisions of about 20 different federal laws that protects employees against retaliation. So if they raise concerns or reporting things to OSHA about violations to their workplace safety and health, it protects them from being terminated in those situations. So employees that actually believe that they've experienced any type of retaliation for doing so actually can file complaints with OSHA. And this actually, the whistleblower program is something that you should have actually in your office anyway already. The poster is specifically called Job Safety and Health. It's the law and it has a little OSHA emblem on it. And that is something that is federally required to be in your office. So if you have your posters and stuff wherever in your break rooms or wherever they might be, this is one that actually should be posted anyway, even without COVID being an issue. So, so yeah, definitely want to make sure we have that. It'd also be a great idea to have a COVID action plan, which will kind of help you solve some of these things all in one. If you don't already have one, that's something you'll definitely want to look at. So the Alliance Group, we do have an action plan, and that is something that we have a template that we are willing to share with whoever is interested. If you don't have one by now, I would probably encourage you to do so. We've pretty much had one ever since this whole thing started and everybody started saying that you should have one. So yeah, it's definitely something that you should look into, and you can definitely reach out to us and we would be glad to share our version of that. But to accommodate all the requirements that are needed in an action plan, honestly, ours is 8 pages. So it's not something that you can write in 1 or 2 pages and cover all the aspects of what should be required in an action plan. So some of the basics of what should be required in an action plan, it should include the responsibilities of management and employees, and each one, what each piece will do. Management needs to make sure that they understand and ensure compliance with this action plan. And then employees do have responsibilities as well. If they're sick, they need to make sure they're contacting management. They need to make sure they understand their time off policies. And they also need to understand the signs and symptoms of COVID so that they're not coming into work with those. If symptoms are present, then they should be tested and follow CDC guidelines, which we'll kind of talk about a little more later. Employees should also be practicing good hygiene while at work, so making sure that they're washing their hands regularly, using hand sanitizers and all that stuff. Don't put that stuff away yet. Additional information should be ways to include practice social distancing within the workplace. So that goes all the way from employees engaging with each other to visitors, employees going out to visit with clients, deliveries. All of that, you need to make sure that we have the necessary PPE based on the type of job. And then maybe some cleaning measures as well. So I know some of us kind of have slacked off a little bit on that. We were probably disinfecting door handles every hour back in the day, but you know, that's something that we still want to kind of keep an eye on and make sure that we're keeping things clean and disinfected. And then finally, a final piece in that is you kind of always want to make sure that you have most current information. And this is the part that will change your policy often because the CDC likes to change every day you wake up. But basically the CDC or local guidelines, as far as what happens when somebody's positive or has close contact, those are as far as differences between vaccinated and unvaccinated or people that aren't fully vaccinated. All of that needs to be in there as well. And we're going to kind of talk about that in greater detail here in a little bit. So, and then finally, once you have that action plan together, it is usually very important in these kind of plans and policies that you have that acknowledged. So it is something that you're going to want to have an acknowledgement form and have all of your employees sign that they have received and or read this plan. So now let's kind of talk about some other options here. Obviously, without the ETS, you can surely create a vaccine mandate, but there's a lot of things you definitely want to think about before you just jump into that. So we'll talk about a few of those. The National Safety Council kind of came up with sort of different levels to kind of think about. So one of them is an honor system. And in that system, you're requiring vaccines to be at work or loosen those mask mandate requirements, but you don't really check the status of people. So if they say they are, we just kind of hope they are. So that's one level to consider. There's a partial requirement that requires workers to either show proof of their vaccination status or submit to weekly testing. One of the things that we've kind of learned so far from the ETS, and it's still sort of a gray area, but at this time, the ETS has stated that any costs incurred by the employee choosing to do the weekly testing wouldn't be the employer's responsibility at this point. So that is something that it's still sort of a gray area, but it is definitely something to kind of look into.
Yeah, one thing though, they do put a carve out in that unless it is required by some other state or federal law. So make sure you check like local requirements.
Exactly.
And the other thing that pops into my mind in HR is the Americans with Disabilities Act. So if they are actually opting out or saying I can't get the vaccine because I have a disability and it's a part of an accommodation, then that is something that you need to look at. And if that's reasonable, because typically employers do pay for accommodations when it comes to ADA.
Yep, definitely.
Sorry.
No, you're good, no problem. Another one is a soft requirement, which basically requires workers to show proof of their vaccination status before they return to specific functions or maybe a non-remote workplace. And then the whole hard requirement that you're flat out requiring all workers to show proof of vaccination status in order to even be able to do their work. So definitely some different levels to kind of think about there. And then I think I went one too far here. Yeah,
Hey,
back
when
to
you're
that one.
can you
There you go.
expand this, like the Alliance here back to show your face? Because I dropped it down. Here, let me do it. I can help.
Should I go
Just
to
right
this?
there and then.
And that?
Yep, okay, cool.
There we go. All right, so
Like
some
to
other, some other considerations to kind of think about here is one, do they have access to transportation and is it feasible for someone to go somewhere and get vaccinated? Not everyone has vehicles that they get around in, they rely on public transportation or other means. So making sure that they have access to be able to do something like that. are you going to offer sick time or some paid time off to get that vaccine? Right now, the typical number that's been thrown out there is up to 4 hours to potentially offer time for somebody to go get the vaccine. Seems like a lot, but that, you know, depending on transportation needs and so forth, that could be something that's needed. And then as well as that, time off to recover. There are side effects to the vaccine that some people get. Some people are pretty lucky and maybe they just kind of feel for a day or so. Some people are pretty down and out for 1 to 3 days, and that's kind of that time frame that they're looking at is a 1 to 3 recovery time. So are you going to help them out during that recovery time because you've required them to get the vaccine? And then the other thing that's popping up right now, especially in the healthcare, can you afford to have your employees quit because they are so hard set, they're not going to get the vaccine? Can your business run if that many people quit, you know, depending on how many people are that strong against it? So another thing to kind of think about. And then there's incentives for those who get vaccines to get vaccinated. One thing to kind of talk about on those, some people are offering like maybe paid time off or gift cards. You know, there's some things to kind of think about on that. The EEOC, one statement that they did make is that you want to make sure that it's not, and their exact words is, so substantial as to be coercive. So you want to make sure that you're not sort of essentially forcing them by coercing, hey, I'll give you $1,000 if you go get the vaccine, when in reality, they have a reason not to. Yeah. So because they have said that in situations like that, some people who probably who are not shouldn't physically get it are getting it because they want that bonus or whatever. So and then gift cards, then you got to start thinking about whether that's taxable wages, those kind of things. So you have to be kind of careful with that.
Included in overtime if they're hourly employees as well.
Exactly. So there's a lot of things to think about on that. If you're not 100% sure, we can kind of help with that a little bit too, but you also may check with your employment attorney if you have one, just to make sure that you're following a proper approach to that and not worried about anything coming up later on. So. All right, now some accommodations that you kind of have to talk about, and Shay sort of touched on that a little bit earlier. So first one is a religious accommodation. So Title VII requires that an employer to accommodate an employee's sincerely held religious belief, practice, observance, unless it's going to cause undue hardship on a business. And we'll talk about undue hardship here in a little bit too. So an accommodation can cause undue hardship if it's costly, compromises workplace safety, decreases workplace efficiency, infringes on the rights of other employees, or requires other employees to do more than their fair share of potentially hazardous or burdensome work. We'll kind of touch on it a little more than that, but you can see how kind of as far as infringing on other rights and compromising workplace safety, how this might be something that's kind of a touchy area because as far as other people are concerned, people coming in not following these mandates or whatever are compromising their workplace safety. So something to kind of think about. If an employee does request this accommodation and there isn't a reasonable accommodation possible, you actually are able to exclude the employee from entering the workplace, but you will want to kind of work with them as far as any other options potentially for them for that. So that phrase doesn't mean you can fire them.
Fire is like the last scenario. You've got to look at all the other options. Can we transfer them to a different position? Can we have them work remotely? Are there other options?
Yep, exactly. So, and then there's also those other equal opportunity laws, federal, state, local laws that you have to look into too, that could potentially keep that from going the way you're wanting it to go. Some other reasonable accommodations under the ADA, a reasonable accommodation is needed if an individual with a disability to perform a job. And again, you're going to have to potentially provide that unless it poses undue hardship. So in those cases, again, you want to try to find alternative accommodations. If it's just absent undue hardship, then you definitely want to make sure you're kind of looking into that. As far as COVID's concerned, there are some reasonable accommodations that we could kind of look at. especially for someone who has a disability that may put them at risk as far as getting vaccinated, those kind of things. There are some low-cost solutions potentially. Some of those could kind of put some barriers up and those kind of things as far as keeping infected areas, designating one-way aisles. We had plexiglass up here for the longest time. That's an option kind of as far as barriers. Maybe using tables or other barriers so that people aren't able to get that 6 foot in that 6 foot distance of each other. You definitely want to be flexible when it comes to this. Both employers and employees kind of have to be flexible with that. It's very important when you're determining some type of accommodation in those circumstances. And like Shay was sort of touching on, temporary job restructuring, marginal job duty changes, temporary transfers to different positions, and modifying work schedules. Some of those kind of things are some things to seriously consider before you claim that it's undue hardship on the company. So, and then we'll talk a little bit more about undue hardship specifically. So what types of undue hardships considerations may be relevant if a requested accommodation poses significant expense during the pandemic. So prior to the pandemic, a lot of accommodations pretty much would have been fairly considered that you probably should do those. It should potentially fit in the budget somewhere, somehow, and you should really kind of think about that. There are a little bit of kind of leniency on that right now because there are some losses of employers' income streams that are happening with COVID. With this pandemic, it's kind of you can actually kind of consider that as far as if there's some losses in your income and things like that. Again, it doesn't mean that you can just automatically reject that just because of the money situation, but it definitely is something that you can help weigh in that consideration as far as if your money stream has depreciated a little during the pandemic there. So
yeah, isn't there like I think there's like a 4-factor test when you're looking at undue hardship, and I can't remember off the top of my head, but there's different things to look at with that. And normally, like Joe was saying, pre-pandemic, it was a pretty high bar. Like it had to be significant financial difficulty in order to reject or to say it's an undue hardship. And then like he said, a lot of time, and the other thing to keep in mind is even if you claim undue hardship, remember there can always be a lawsuit in which people can argue with you on that. And then like the trend is, like I was saying to him, lately employers or the case law from what juries are feeling and things like that, from what I've heard from a recent labor law forum, was that they are really expecting employers, like if before you fire somebody, that you need to walk through all the things of different things that you could do, like alternate positions and stuff like that, before you just straight out the gate terminate them. And then if that accommodation doesn't work, like Joe said, there's alternate accommodations maybe that we can do. So that's part of that interactive process. So maybe, no, we can't have you fully remote, but can we have you remote certain times of the week? Or come in and change your schedule so that you're not here at peak times and things like that. And Alliance Group, we can help if you want to call us, bounce off anything off the HR team. Hey, I've got this religious accommodation, or I got this ADA accommodation. Give us a call. We're happy to help walk through that.
absolutely. Thank you, Shay. So there's been kind of some questions as far as what's really considered recordable when it comes to COVID. So we'll touch on that a little bit. Initially, OSHA had said that you'd have to record any adverse reactions related to the COVID vaccines if you had a vaccine mandate and actually required the vaccine. Apparently, there was a lot of confusion as to what that line is between what's required and voluntary. I'm not sure. I guess I understand the difference between the two words, but there was some people were a little confused with that. So OSHA did right now change its stance on that. And at this point, they are not requiring you to record vaccine side effects for at least the next year. And that ends on May 20th, 22. So right now, that's the way it is. We don't know what's gonna happen at that point, whether they'll change that. They also did that because they didn't want to discourage employers from their vaccination efforts, where they thought maybe people wouldn't want to do it if they're gonna have to deal with all the recording of side effects and those kind of things. So, but there are definitely some record keeping requirements. COVID-19 is considered a recordable illness, and employers are responsible for recording cases of COVID-19, kind of if the following takes place. So 1, the case is actually confirmed to be COVID-19. 2, the case is work related, which I will hit on here in just a minute. And then 3, the case involves one or more of those general recording criteria, which we'll talk about here in actually another minute. So, sorry, I went too fast there.
Oh, you're good.
All right, so how do we determine if the case is work-related? It is sufficient in most circumstances for the employer when it learns about a COVID illness from an employee to be able to ask the employee how they believe they contracted the infected illness. So you're kind of able to determine whether or not it was a potentially workplace. And then also, while respecting the employee's privacy, there's a fine line, unfortunately, but you can kind of discuss as far as some potential outside of work activities that could have led to the situation. That will kind of help you determine if it really is a workplace versus an outside of workplace situation. And then also review the work environment. Are other people in that this employee works around, are they now getting positive COVID cases as well? And that might kind of help you determine if there's maybe some type of situation inside work where there's been an exposure and it's going around. So that second one, outside of work, you do really want to be careful with that one, but they did actually say that that is a way that you can help determine if it's inside work or not, because you kind of need to figure out where that originated. So
Yeah, and is it from a safety perspective, Joe, is it important to make sure that you accurately record, like don't over record on your OSHA log, right? Because
exactly.
that can impact your DART rate, which can get you possibly inspected. Correct?
Exactly, and that's kind of why you really want to do that investigation to kind of help determine. So, because somebody can easily say that it happened at work, but you know, they were at the bar all weekend too, and all that kind of stuff. So it's kind of, you know,
Yep.
then it's, you know, you're dealing with, it could have happened anywhere. So, and then are there situations where an injury or illness occurs in the workplace, but it's not actually considered work related? And here's another tricky piece. So, if it happens at the workplace, but isn't actually work related, it's not recordable. And one of the situations they mentioned is the employee comes to the workplace, but they're not actually working. So they're just kind of there as a general public. In that case, that's not considered a workplace recordable related incident, because the person wasn't physically there working and clocked in and on their time. So kind of one of those gray area things. And then the injury or illness involves signs or symptoms that surface at work, but are actually solely from a non-work related event, kind of like I just mentioned earlier, where it happened exposures potentially outside of work. So in that case, those wouldn't be work related and they would not be reportable. That general recording criteria that we kind of mentioned earlier, if it results in any of the following, which is death, days away from work, restricted work or transfer to another job, medical treatment beyond first aid, or loss of consciousness, all of those kind of things are usually kind of that general recording criteria that OSHA would require some type of recording on the OSHA 300 logs.
So if the person, let's say the person gets, sorry, I keep interjecting.
No, you're good.
So what if the person, they get COVID, it's diagnosable, but they don't go to the doctor about it. It's just like they got a test. They worked remotely the entire time. They didn't miss a full day of work ever. Would that be a recordable based on what you said?
Based on what it seems, I wouldn't think so.
Okay.
But yeah, it's it's sort of still that there's a lot of gray in this. It's really hard to tell.
Yeah,
So it's more almost a judgment thing at this point, because they haven't been very, very clear with that. I was sort of hoping in the ETS that they would be a little bit more clear so we could at least use that whether it happens or not, but they're still not even very clear in there. So, so you
Interesting.
sort of have to really kind of dig into it and really figure out where
I
that might
just feel
fall.
like a lot of people like have had that instance where they're just working remotely, so that says.
Yeah, yeah, exactly.
Joe, you do have there's a chat
Oh,
question in here as well. I want to click that open.
So-
Jeff Phelps, please.
if we mandate the vaccine and the employee ends up being hospitalized due to adverse effects of the vaccine, is the employer reliable for that? in any
Yeah.
way? So potentially, depending on as far as,
Yeah,
you know, it's again, kind of the workplace situation. I mean, especially if it was originated in the workplace, if you can determine that, then yeah, we could potentially be looking at that. I haven't seen a lot come across as far as any lawsuits specifically about that, but right now, it mostly goes back to that, determining if it's a workplace situation or
so if they
just.
mandate the vaccine though, and somebody gets sick from the vaccine, I think is what they're asking.
Oh, more of the vaccine.
Yeah, so-
mandate.
Would they be liable because they told the
It's,
person, you have to get this vaccine, and then they got sick from it?
Yeah, and in that situation, there definitely may be some type of liability. I would probably,
Yes,
kind of
yes,
check,
that's
you
what
know,
I
with
think.
their, employment,
Yeah,
law person a little bit on that, to kind of clear that up.
yeah,
And get the situation explained a little better, but yes, I think in that situation, there could be, yes.
yeah. And Jeff, if you have if there's a specific case or something that you want to ask us, please feel free to give us a call. We'll listen to the situation, kind of hear what the details were and give you our best advice. So feel free to give our HR and safety team a call later this afternoon if you're free. Oh,
Another chat.
pop that open real quick.
Okay,
Perfect.
thanks, Jeff.
Perfect, thank you, Jeff. So now we'll kind of talk a little bit about what the current CDC quarantine and isolation guidelines are. There's a lot of changes on that. Not necessarily daily so much anymore, but it does change fairly frequently if things get updated or new studies or whatever. But right now, one thing you can do is consult with your local health department on some of the local rules and guidelines. A lot of health departments are sort of stepping back a little bit and just sort of following the CDC guidelines for the most part. But you do want to check like within county health departments and stuff. I know in Nebraska for a while it was separate based on counties. Some counties had stricter guidelines than others. But it sort of seems like a lot of them are just starting to fall in line with what the CDC says because of kind of the time frame here for now. But we'll sort of start off here on the difference between quarantine versus isolation and what is close contact. So let's see here. Did I skip a slide here? Sorry about that. All right, so first off, quarantine is basically described as keeping someone who's been in close contact with someone that's been positive, kind of keeping them away from each other, from other people. Isolation itself actually keeps someone who's physically sick and positive with COVID, whether they're sick or not, I guess, if they're positive with COVID, away from others, including the people in their home. We'll kind of talk about that a little bit more here in a second. And then close contact. This one's actually kind of had some extra information that I found out that was very interesting. So anyone who's within 6 feet of an infected person for a total of 15 minutes or more over a 24-hour period. A lot of us kind of thought as if you were with them for 15 minutes, or less than 15 minutes, then you're fine, but it's actually over a 24-hour period. And it's, yeah. So in that situation, if you had 3 5-minute exposures within 24 hours, there's your 15 minutes. So, so that's something that a lot of people didn't really realize. While you wait for that test, if you are going to test during that period, you'll want to kind of think about who you've had close contact with over the last couple of days, or where your symptoms began, or where you were positive for that test. And that'll kind of help with those tracing efforts and sort of help slow the spread between workplace or community and that stuff. And then a person's considered close contact, actually, even if they're wearing a mask. So at that point right now, at this point, that's kind of what they're saying, is even the masks don't eliminate you from being close contact. There may be some less restrictive guidelines, but you're still considered close contact. There are some exceptions to that close contact definition in those K through 12 classroom situations. But those you're going to want to kind of talk about with your local health department, because those are kind of changing per school districts and local health departments and things like that. But I just wanted to throw that out there, that there are definitely some differences between people going to school and people coming to work and what those guidelines are. So, and then another big one that came up that actually could extend quite a bit of time, that you could potentially be out. So if someone is in quarantine and watching for symptoms due to close contact, it's not considered close contact for other people in the house. So I came in close contact with someone and I had to follow these rules, but everyone else in my house, that doesn't mean that they have to, unless suddenly I have a positive COVID test or I'm starting to get symptoms. Then in that case, they could be considered close contact. So, so kind of another one of those gray area things. And then next, we'll kind of talk about the quarantine guidelines. So there are different quarantine guidelines based on if you're vaccinated or not. So if you're fully vaccinated, you don't have to quarantine unless you have symptoms. They suggest that you do get tested in 3 to 5 days after your exposure, even if you don't end up with symptoms. And they do ask that you wear a mask in public for 14 days following that exposure, or until you have a negative test result.
So this is if you're exposed, right?
This is if
Because
you're exposed.
positive,
Yeah,
they
this
say
is only if
14
you are a close contact.
Okay.
If you're exposed, yeah. And then if you're not vaccinated and you're considered a close contact, then you're supposed to stay home for 14 days after the last contact with that person. And then you'll kind of want to watch for some symptoms, a fever, which they consider as 100.4 and higher, cough, shortness of breath, or some other symptoms. And those symptoms kind of have changed based on different variants. Like I know a lot of people now are feeling like they have a sinus infection, and it's actually the new variant of COVID.
Mm-hmm.
So it's kind of some things you want to watch for. And then if possible, definitely stay away from other people that you live with, especially if they're at higher risk of getting COVID-19. And then you can definitely kind of talk to your public health department as far as some options to lessen that quarantine. And then one of the really tricky ones is if someone that you're taking care of that's positive with COVID-19, you have daily contact with that person because you have to take care of them, and you can't stay 6 feet away from them, your 14-day quarantine doesn't start until their 10-day isolation is over. So in that situation, you could potentially be out for 24 days in those situations if you're with that person those whole 10 days. So, so another big one to kind of think about. So, and then as far as
That's what I'm saying. Sorry.
so now as far as isolation, so these are people who are actually sick and have been tested positive for COVID. So if you're sick and know you have COVID, you need to actually stay home until at least 10 days have passed since your first symptoms appeared, and at least 24 hours without a fever and without the use of COVID, or I'm sorry, fever reducing medications. So that's something that you kind of want to make sure that you're not using that to keep your fever away. And then it says symptoms have improved. And then just a little snippet on that is there are situations where like the cough and some of those kind of things do linger for some time. So you don't want to necessarily hold somebody back from being able to come back to work because that cough is sort of hanging on there a little bit. But if the symptoms are improving for the most part, and maybe just that's lingering, that's something where they can technically come out of their isolation at that point. If you don't have any symptoms, but you tested positive, you should stay home until after those whole 10 days have passed. But if you develop symptoms, then you kind of have to back into the whole, I got sick now, and follow those guidelines. So, so that's kind of as far as the COVID stuff. Let's see, we do have a chat here.
He's just sending that over to us. You're good.
Okay, all right. So now we're sort of done with some of the COVID stuff. We'll kind of touch on a few other things here real quickly.
Yeah, we've got about 5 minutes, Joe, just FYI,
Okay,
5-10 minutes.
all right. So we'll kind of hit on these real quick. There's some HR things that are in these top 5 of many of the current law firms that specifically work with employment law. And one of the top 5 that they're really pushing right now is diversity, inclusion, and equity. So that's sort of one of those things that we are, they're encouraging people to kind of start looking into. A lot of this has to do with some of the social justice movements that have happened in the last year and a half. Some places are kind of struggling with how to understand the complexity of this diversity and inclusion, sorry. So back in 2020, some places have started to kind of do this, but it's a trend that a lot of places are definitely wanting to kind of start looking at. And then given the focus and emphasis on equity, and that's just so you know, is the quality of being fair and impartial. You may want to kind of consider to make sure that equity is involved in your D&I efforts and incorporating some of those things. So creating a training program and developing programs that embrace that, supporting inclusiveness in policies, and using honorifics. And for those that aren't sure what honorifics are, that's like gender. Some of them refer to gender, like Mr., Mrs. and such. There are some new honorifics out there that kind of combine and are inclusive for everyone. And then updating facility signage, restrooms, those kind of things that may be inclusive. And then culture, promoting culture on social media and those kind of things as well. So there have actually been a couple lawsuits. One of the Supreme Court, Bostock versus Clayton County, and that was one of the civil rights lawsuits where employers are not allowed to discriminate against applicants or employees based on the basis of their sexual orientation or gender identity. So this is something that is definitely become a big issue that you'll want to kind of consider as well.
And just to add on, we do have actually a diversity training now here at the Alliance Group. If you want to reach out, we don't, it's not like a core training like the harassment training, but it's an option. If you're interested, reach out to me.
Minimum wage, just real small. There is a federal contractor executive order minimum wage. So $15 an hour is what that will be starting January 30th, 2022. We'd all like it to be that $1 million an hour.
Yeah.
And then there are several states that do have some. As far as our client base, primarily Colorado seems to be the main one that has an increase. So effective January 1, it's $12.56 for Colorado. So just a quick touch on that. Sorry, I'm kind of going back through these a little quick since I'm short on time. Another one is ban the box laws. That's something that actually has been around a lot longer than I realized. Hawaii was the first state in 1998 to actually initiate these kind of laws. And what that does is it refers to removing criminal history checkbox on employment applications, basically allowing you to go through the whole interview process and determine if this person is actually qualified to do the job before you even start thinking about any type of criminal history or anything like that. So there actually is a Fair Chance to Compete for Jobs Act of 2019 that has passed where federal employers are actually required to go that route now. And then I know that there is a couple Congress men and women that have actually put one out there, a Workforce Justice Act, that's trying to kind of get that passed through that will actually make it for private employers. So then it would be a federal thing and not just some states and local places that have that. So
Yeah, and it could come into question as well, with adverse action, and if there are certain protected classes that are being eliminated or not being considered for positions, because of your, hiring practices. So the EEOC does have guidance on that. And again, reach out to us. We can help give, some guidance on how to build like a criteria matrix and stuff to make sure you're being consistent with decisions. And that the things that you're looking at are really job related when you're looking at those criminal offenses. So contact us and we can help.
all right, so I got two other quick things I'm just going to throw out there real quick. Another one that is very, very popular on those employment sites is flex work in arrangements and work-life balance. Something that really has come up a lot during the pandemic. And now a lot of companies have seen that it is possible to have flexible schedules and flexible work environments where people are working from home and doing various hours. It's definitely been proven to help employee morale. There's been boosts in productivity, believe it or not, instead of the other way where you thought everyone's going to go home and no one's going to work. They've actually seen a lot of boosts in productivity. And I know I've heard of some companies that are actually considering not even like opening as big of an office that they used to have, and they're going to have a lot of people just working from home. So it is something to kind of think about also as well. And we can share some information on that if you're interested in talking further about that. And then a quick safety one that I wanted to touch on is right now the National Safety Council is urging employers to kind of look at their workplace impairment policies. It's a huge topic. This has quickly become top 3 of the National Safety Council's concerns. It used to be worrying about slipping and tripping and falling and those kind of things. But workplace impairment has become huge, and majority of it is because of the opioid issue. So basically there's been some new provisional data from the CDC that drug overdose deaths between April of 2020 and April of 2021 were over 100,000, as you can see on the chart over there. Last year, there was only 78,000. So we've seen a dramatic increase in that opioid use, basically attributed to the pandemic. There was a lot of fear, concern, anxiety, and those kind of things. And in that same survey, they found that only about 17% of employers actually felt comfortable in this situation. So it is something you definitely want to do. Some of the common things, obviously, that they discussed is alcohol, cannabis is a new big thing, fatigue, mental distress, and more different types of impairments as well on that.
And opioids, I think, right?
Yeah, opioids is a big, the
misuse.
prescription drug misuse is a big piece of that. So, so right now they're saying that the average is 235 lives a day that are being lost due to drug overdose. So they definitely are thinking that we need to take some serious action on this and find some ways that the workplace can get involved and help with this. So
You have got, looks like you have a few
Yeah, we have some in the
messages
chat.
in the chat, so let's.
all right, so let's kind of see here real quick.
And then we also have, so on that, getting involved if there is drug problems, remember that we have an employee assistance program through Guardian at the Alliance Group, and any of our clients can use, I believe, even if they're not on Guardian. So that comes in handy too, if you think someone might have a problem with addiction, giving them that resource to call is confidential, and then they can link them up with counselors to help.
Yeah, and this is coming directly to us, Joe, so I've talked to Amy, I think Amy's gonna reach out to
Okay.
Jeff.
Good job on that.
Yeah.
Okay, all right. Sounds good. Is that the only thing? Looks like it was all
Yep.
together. All right.
Awesome. Well, thank you
Okay.
very much, Joe. We appreciate
Yes.
research and the time you put into the presentation, and thank you
Yeah,
very much.
absolutely.
Yeah, thank you.
All righty, we will come back right around 1 o'clock.